Good afternoon, selamat siang. Welcome back. We'd like to begin this session. I'm Ronit Ritchie, and in Greg Feely's name and my own, I'd like to thank you again all for coming, for being here, and offer special thanks to all of our speakers, chairs, and discussants, and of course to everyone at the Indonesia Project for all of the hard work throughout the year that makes an event like this possible. We had an absolutely fantastic start to the day, and after the two great presentations and discussions we had this morning, we now begin the thematic part of the update, which this year focuses on minorities in Indonesia, the lives of minorities, their struggles, their aspirations, and also the ways in which they might feel a sense of belonging or not to Indonesian society. And in thinking about this theme, we would like to consider, in addition to discussing the position of various minorities and their status within the state, we'd also like to think of minorities as a lens or as a gateway to what is happening in Indonesia today. So thinking about minorities involves thinking about religion and ethnicity, about the gap between creating laws and implementing them, about how ideas and movements that emerge far from Indonesia's shores impact Indonesian perceptions. It makes us think about Indonesia's place among the nations in comparative perspective. And it also allows us to think about the power of discourse to shape politics and everyday lives and more. So these are some examples of how thinking about minorities is not only thinking about this topic per se, but also what it allows us to see about Indonesia and the bigger picture that emerges. But before considering any of these issues, we have to pause for a minute and ask ourselves, what do we mean by the concept of minority? What is a minority? What does it mean to be a minority? And how has that idea or that concept changed over time? And it may seem like a very self-evident word that we use often, but it is actually not self-evident at all. So in order to explore this question and provide us with a point of departure or kind of a baseline for our debates in the next 24 hours, Greg and I thought we could find no better scholar than Professor Robert Cribb, who has kindly agreed to give the keynote and whom I will now briefly introduce to you. And I'll do it briefly because I think Robert doesn't really need much of an introduction with this audience. But nonetheless, Robert Cribb is a very prominent historian of Indonesia and has contributed immensely to our field through his teaching, his mentoring, and his publications. He's been here at the ANU since 2003 and is currently professor at the Department of Political and Social Change. He's been the recipient of numerous grants and the winner most recently of the New South Wales Premier's History Prize for his co-authored book, Japanese War Criminals, The Politics of Justice After the Second World War. Professor Cribb is the author or co-author of 8 monographs, 6 edited volumes, and dozens of articles and chapters. And one of the things that impresses me the most about Robert's record is that without giving up in any way on depth in his writing, he's also able to cover a very, very wide spectrum of topics with research and writing ranging from environmental politics in colonial Indonesia to legal pluralism and criminal law in the Dutch period, to the Indonesian Revolution, to the massacres of 1965, to the dynamics of academic life in Indonesian studies, and the creation of a digital atlas of Indonesian history. And I could go on, but I won't. I'll stop here in order for us to have sufficient time for the actual talk. And I now invite Professor Robert Cribb to speak on Ambiguous Advantage, Minority Status in Indonesian History. Thank you.
Well, thank you very much, Ronit. Good afternoon, ladies and gentlemen. Thank you very much for coming along. Already in Virginia's introduction this morning and in Ronit's comments, we've come across the problem of defining minorities as a phenomenon in Indonesia, and we'll come across this problem many times over the coming sessions at this update. It seems to me that there are two principal definitions. There's an older definition which describes minorities simply as ethnic and religious groups that differ substantially from the majority community. But that older definition has been significantly displaced by a newer definition which stresses, or rather which identifies minorities as communities which are somehow prevented from enjoying the full benefits of citizenship. So whereas the older definition stressed only identity, the newer definition stresses some form of disadvantage within the political system. Now, I'm going to use that second definition in my presentation, but that isn't to say that it's the only definition that should be used. And in some of the presentations that we're going to hear, I think we'll find that the older definition is actually much more appropriate. Now, we're going to have quite a lot to criticise in Indonesia when we discuss the position of minorities. And so I think it's useful to start off with a reminder that Indonesia's 1945 constitution was a qualified triumph of civic inclusionism. It was a qualified triumph for groups that might otherwise have been minorities in Indonesia. It swept away the elaborate, or most of the elaborate apparatus of legal differentiation amongst Indonesians that had been a cornerstone of the Dutch system, and it sought to create an Indonesia that everyone, or at least every indigenous person in the archipelago, could believe in and could see themselves as a full part of. Now, we know that that ideal teetered at various times because of accusations of Java-centrism. We know that it failed completely in East Timor. We know that it hasn't been particularly successful in Papua. But nonetheless, it's really important to remember that Indonesia stands out ahead of all its Southeast Asian neighbours. And indeed, it stands ahead of Australia until 1967 in terms of its civic inclusiveness. But I called the Constitution a qualified triumph. It was qualified because, in fact, it created three minority groups. Two of them were created by Article 6.1 of the 1945 Constitution, the article which provided that the Indonesian president must be asli, must be native or indigenous. This provision authorised a form of racial classification, because you obviously can't have a provision in the Constitution that restricts ethnicity unless you classify ethnicity. And it implicitly permitted other kinds of discrimination, despite the other clause of the Constitution which said everyone was equal before the law. Now, the two groups that were affected by Article 6.1 were the Indo-Europeans or Eurasians, and Chinese. And there's interesting parallels and differences between the experiences of those two groups. The Indo community came into being because of the long Dutch male presence in the Indonesian archipelago, and because in Dutch legal thinking, patriarchy trumped race. So the recognised children of a European man were European, regardless of what colour they happened to be. So by the 19th century, there was a significant mixed-race settler community in the colonial Netherlands Indies, and that community did what its counterparts in the rest of the world were also doing, which was start to toy with ideas of nation and nationalism. The first stirrings came in the 1860s. And by the 1880s, there was a movement in the Indonesian archipelago led by Eurasians, which said, we have to detach ourselves from the colonial order, put ourselves in the leadership of the whole of the archipelago, the indigenous people as well, and bring this archipelago to independence. Now, just to the north of the Netherlands Indies, there was the Spanish colony of the Philippines. The equivalent social group to the Indos in the Philippines were called Filipinos. And they were the ones who took charge of the Filipino Revolution. They were the ones who became the core of the national leadership in the Philippines. Indonesia appeared at one stage to be heading in that direction. But of course, it didn't happen. It didn't happen partly because there was a religious difference between the Indos and the majority population. But it also failed to happen because of the ethical policy, the Dutch policy of development, which was introduced at the beginning of the 20th century, and which was conceived, amongst other things, as a partnership between Dutch metropolitan planners and a new Indonesian elite. And in that partnership, the idea was that the Eurasians would be squeezed into the margin. They wouldn't any longer be able to be the spearhead of a nationalist movement. So during the first half of the 20th century, the Eurasian community was both encouraged to believe that its future lay in sustaining the colonial system, but also the emerging Indonesian nationalist movement was encouraged to see Eurasians as one of their greatest dangers. So the Eurasian movement, the idea that the Indos would lead an independent archipelagic nation, survived right up until the 1940s. And I should say, Article 6.1 was above all intended to ensure that there would never be a Eurasian president of Indonesia, not that there would never be a Chinese president. So that particular channel in Indonesian history was brought to an end. The other group that was excluded, of course, was Chinese, who were resident in the archipelago, a much larger community, probably 10 times the size of the Indo community. But amongst them, there were people who felt they were entirely part of the Chinese community, others who felt they were part of the archipelago. They were there as a result of years of migration, centuries of migration into the archipelago, sometimes what was meant to be temporary migration, but which turned into permanent residence. Now, in the 1830s, after the East Indies Company had been abolished and formal Dutch colonial rule was put in place, the population of the archipelago was divided into two categories, Europeans and natives, and in each of those categories, plus those who were equated with them. Now, Chinese were equated with natives in this early system of racial classification. Almost immediately, there was significant pressure from the Chinese community to get closer to European status, particularly for business purposes. That pressure grew stronger during the 19th century. It became intense after 1899, when the Dutch government recognized Japanese as Europeans. This produced the anomalous situation in the 1920 census, where in eastern Indonesia, Japanese was one of the most widely spoken European languages in the archipelago. Chinese resident in the Dutch colony were deeply offended that Japanese should have European status and that they did not. And this only enhanced the pressure to push the Chinese community closer and closer to European status. In 1925, the former two racial categories were divided instead into three. The category of foreign Orientals was formally created. And by the end of the colonial period, what had happened was that the interests of a large part of the Chinese community appeared to have been tied to the colonial order. In a sense, it was even more difficult for Chinese than for Indos, because the radical stream amongst Indos aligned with archipelagic nationalism. The radical stream amongst in the Chinese community was engaged in Chinese politics. So these two communities, the Indos and the Chinese, were significantly alienated from the nationalist movement that emerged. I should have added that the ethical policy Dutch also portrayed Chinese as enemies of the mass of the Indonesian people in the way that they portrayed Eurasians as the enemy. So both groups, partly through their own doing, partly through Dutch policies, were significantly alienated from the nationalist movement at the time of independence. So the Article 6.1 was very much understandable in those contexts, in that context. Now, both groups paid a very high price for this alienation. During the revolutionary years, there were massacres, the pogroms, there were individual killings, there was great destruction of property. The Indos suffered more than Chinese. Many thousands of Indos were killed, many hundreds of Chinese were killed. Umbanese, Manadinese, Timorese were also targeted on the grounds that they were assumed to be associated with Dutch colonialism. And it didn't stop with the transfer of sovereignty in 1949. Both Indos and Chinese experienced a great deal of casual discrimination. They experienced official discrimination. They experienced very messy procedures for confirming their Indonesian citizenship. There were various kinds of expulsions of people who had not taken Indonesian citizenship, right up until the late 1950s. At that point, the trajectory of the two groups diverges very substantially. They're strikingly parallel up to then, but they diverge from the late 1950s. Indos ceased to be a salient minority in Indonesia, whereas the Chinese remain as a salient minority. Now, why is this the case? The answer that has traditionally been presented is that it's to do with Indonesian racism. The problem with that analysis is that there's actually been very little investigation of the nature of Indonesian racism. Those who have looked at prejudice against Chinese in Indonesia in the context of prejudice amongst other ethnic groups in Indonesia have found that although Chinese Indonesians stand at the top of the list of those about whom there are prejudicial judgments, they're not off the chart. How many of you have heard prejudices about Minangkabau, or about Bataks, or about Bugis? Yeah. So Chinese are there. They're at the very top of the list, but they're not off the chart. There's racism, but it's actually very hard to pin down why racism would translate into the experience of Chinese from about 1960, which is in many ways a terrible experience, an experience of repeated outbreaks of violence, an experience of a great deal of casual discrimination, public denigration, and restriction on freedom of cultural expression, restriction on names, restriction on celebration of New Year and religious observance and the like. The elephant in the room, it seems to me, is the political economy of protection, something that we've already heard something about. We now understand, particularly thanks to the work of Jess, the huge role that the military played in the mass killings of communists in 1965-66. We know when we look at the political economy of the army in Indonesia that income from protection is hugely important. Income from other illegal activities is hugely important. I think we need to wind back our assessment of the importance of Indonesian racism and wind up our understanding of the specific role that squeezing Chinese Indonesians played in Indonesian military finance. And it's particularly clear now that the new order is 20 years in the past. There's been relatively little expression of clearly anti-Chinese violence in the last 20 years, especially the last 15 years. So we have a period of intense ill treatment of Chinese, which is also bracketed by the period of military dominance. Now, this is a big issue of interpretation in Indonesian politics, Indonesian history. And in many ways, the Ahok case that Tom described this morning is a touchstone for how we understand what is going on. We have 4 explanations on the table for the campaign, the mass campaign against Ahok, and his defeat in the Jakarta gubernatorial elections. One is that he was Chinese. The second is that he was Christian. The third is that he was a tin-eared bureaucrat or technocrat who didn't didn't pay attention to the consequences of his policy for ordinary people. And the fourth is that he was a blasphemer. Now, the problem with the arguments that refer principally, now I have to say all of those are going to be part of the explanation, but the problem with the arguments that focus on either Chineseness or Christianity is that these were being pumped into the debate well before the effective campaign against Ahok, and they weren't having very much impact. Now, the argument about Ahok being a tin-eared technocrat is one I've got a lot of sympathy for. I work in an Australian university, so I encounter quite a lot of tin-eared technocrats. But if we look at what was actually happening, it's very clear, to me at least, that it was the accusation of blasphemy that made the difference. That was what brought people into the streets in vast numbers against Ahok. I know we have heard arguments that this was a kind of manipulation of popular opinion, but I think we have to take seriously what the people who were actually in the street said they were doing, what they thought they were doing, what they thought they were protesting against. And in considering these motives, we come to the third minority that I mentioned that was created by the 1945 Constitution. And that minority was Muslims. Now, this is not something that is usually said, but the 1945 Constitution gave no special recognition to Islam, even though it was the religion of the vast majority of the people. The Jakarta Charter, which would have obliged Indonesians Muslims to follow Islamic law, was omitted. Pancasila says ketuhanan. It doesn't refer to Allah. It puts all religions on the same basis. Only pious Muslims, amongst all other indigenous Indonesians, were in a position of feeling a bit disappointed with the Indonesia that they got in 1945 or that they reclaimed in 1950, because it didn't quite meet their political expectations. So there was this paradoxical situation. There were a majority of the population, but a minority in terms of the group that wanted to have Islamist or Islamic forms in the state. They tried very hard. There was a Darul Islam rebellion in the 1950s and 60s. They tried in the Constituent Assembly that was elected in 1955, and they failed. They were marginalised in guided democracy. They were marginalised in the New Order. Wertheim, W.F. Wertheim, the Dutch sociologist, in fact, coined the expression majority with a minority mentality to describe the position of Muslims in Indonesia in this period. But it changed. Thanks to patient, gentle dakwah, to careful pushing of proselytization, pushing of basic Islamic principles, the heterodox forms of Islam were in retreat. The aliran abangan, which was once such a prominent part of Indonesian politics, became much less abangan-like. The minority, the de facto Islamic minority, became a majority, and now it expects what it sees as majority rights. Now, this transformation is masked by the fact that there is a rich diversity of opinion amongst Indonesian Muslims. It's not that all Muslims, of course, are asking for the same thing. They don't necessarily want an Islamic state. But a very large number of Muslims do want it to be clear now who is in control. It seems to me that collectively, Indonesia's Muslims are channeling John Howard and saying something like, we will decide the meaning of Islamic law in this country and the terms on which it is introduced. In this situation, the very sharpest of the cutting edges is blasphemy. Blasphemy is something that can unite all Muslims. There's no consensus amongst Muslims on anything else about the Islamic State, but there is a strong consensus, don't mess with us. Don't tell us what is and what is not blasphemous. So we heard a question earlier, whether the use of the accusation of blasphemy was a false accusation. This is not a judgment that any of us who are non-Muslim is permitted to make. This is a judgment that's made within Islam. And we don't just see this issue in the case of Ahok, we see it in the case of Mailiana, who is accused of insulting Islam. We see it in the case of the Ahmadiyya and the Shia, and we see it in the broader Islamic world in the case of the Muhammad cartoons. Now, many of you will know that the prohibition on depicting Muhammad was introduced originally to prevent the veneration of Muhammad, so that he wouldn't be treated as a god. It's now turned into a mark of respect for Islam. But that's not for us to say. Just in case you think that obsession with blasphemy is an exclusively Muslim phenomenon, I just remind you, those of you who are familiar with Australian society, a couple of years ago, one of our Muslim public intellectuals tweeted, "Lest we forget Manus Nauru," and was excoriated for what seems to me to be a kind of civil blasphemy. More recently, one of our senators referred to a final solution and was similarly excoriated for civil blasphemy. Now, we don't burn people's houses down, but we get offended by blasphemous expressions, and we need to recognise that what we do is not necessarily different in its in that sense of moral outrage from what happens in Indonesia. Nonetheless, what we seem to be seeing in Indonesia is a minoritization of non-Muslim religious groups that is unprecedented in Indonesian history. If we look back to the original formation of Indonesia, there was a strong principle of religious equality, which is now being seriously eroded. There's another way in which minoritization is taking place in contemporary Indonesia, and that is in I'm well in control, surprisingly. And that is in the context of the discourse that identifies or that refers to putra daerah and to masyarakat adat. So putra daerah, literally son or child of the region, is the slogan that is used in its mildest form to insist that elected representatives from a region come from that region. We're very familiar with that kind of insistence in other parts of the world, including Australia. It has an ugly side in the portrayal of internal Indonesian migrants as alien in territories where they have migrated. And we've seen a couple of examples where this discourse of internal ethnic cleansing, of internal ethnic disciplining has taken place in Sampit in 2000 and in Tarakan in 2010. Masyarakat Adat is the Masyarakat Adat movement is the Indonesian manifestation of the movement of indigenous peoples throughout the world. It's part of a transformation of the definition of indigenous from simply people who happen to have been born in a place to communities who have retained, or in some cases rediscovered or reinvented, cultural traditions that bind them to a particular area, to a particular limited land. Now, both these movements have, I think, have noble, important motives. They're intended to protect fragile, small, local cultures from being swamped by larger migrant communities, from being subject to those powerful, solvent, assimilative forces that occur everywhere where large groups are placed next to small groups. Nonetheless, they're part of what I think is a very ugly family of political thinking, which includes Brexit and Trump and Stop the Boats and segregation and ghettos and ethnic cleansing. The idea that certain territories within a country become no-go. I should have added gated communities to that list. The idea that certain areas become no-go is, in many cases, a rather serious infringement of broader human rights. If we put together this discourse of Putra Daerah and Masyarakat Adat with the discourse that minoritizes non-Muslim religions, we can see that several of the pieces are in place in Indonesia for a process that I would call not disintegration but de-integration. There are several words you could use: hyper-devolution, or internal secession, or cantonization, from canton, the key political unit in Switzerland. Now, when we think about Switzerland, we mostly think about Lindt chocolate and cowbells, and it's all very sweet. The canton system in Switzerland was built after decades of bitter and brutal warfare in the late 19th century and late 18th and early 19th centuries. The Swiss National Tourist Bureau doesn't tell you about those things. We can see this cantonization process building coherent communities on the basis of brutal ethnic cleansing in the Balkans, in the Caucasus. Clear evidence that it's not at all just a Muslim phenomenon. So it's not a direction that we say that I would suggest is definitely occurring in Indonesia, but today we can see many more of the pieces present in the Indonesian polity than once was the case. Now, what's the implication of cantonization in Indonesia, of dividing Indonesia up into more autonomous units which are dominated by just a single religious group or a single ethnic group? Well, I know many people are enthusiastic about the capacity of local government to have its ear close to the ground and to listen to local aspirations. But historically, cantonization is not a force that favours human rights. And let me explain why that is the case. from about this is a gross historical generalization, from about the middle of the 18th century until about the middle of the 20th century, 2 centuries, the discourse on human rights focused on the rights of the individual and on the rights of the citizenry within the state. So the rights of citizens to determine who would rule them. Since the Second World War, we've become increasingly conscious that rights that seem natural for white, male, adult, heterosexual human beings are not always expressed in terms that sum up or that express the needs of people who are not in that restricted category. And so as a result, we've had a whole range of declarations, some from the UN, some not from the UN, but assertions of the rights of specific groups, of women, of children, of refugees, of the disabled, of sexual minorities, LGBT, of great apes, something that's close to my heart. Some of these are official, some of these are not official. The distinctive thing about all these groups is that they cannot secede. They can't leave. They can't be expelled. They can't be given their own canton. They're part of society. To be a minority in a canton is generally a lot worse than being a minority in a larger community. And this was actually the understanding on which Indonesia was based in the first place. People across the archipelago flocked to the idea of Indonesia because it took them out of intense local power relationships, gave them a vast national stage on which they could seek their opportunities, seek their future on the basis of their rights as an individual, on the basis of their rights as a human being, and on the basis of their capacity. And it worries me in this implicit cantonization process that something very special about Indonesia is under threat. So, thank you very much.
Thank you very much, Robert, for a very interesting and very thought-provoking talk. We have time for some questions because I also thank you for ending about, 7 or 8 minutes before the time. So I'll take maybe 2 or 3 questions at a time, and please try to be brief. Okay, yes, please.
Charles Koppel, University of Melbourne. Robert, I wonder if you could respond to a question about the place of the national motto, Bhinneka Tunggal Ika, in the context of what you've been talking about. It seems to me that it encapsulates a lot of these things, but it depends on the meaning you attribute to the phrase, whether you see it as a statement that we are united in our diversity, or whether you are saying we should achieve unity from diversity. I wonder if you'd like to comment on that.
Wait, let's take 1 or 2 more. Yes, please.
Yeah, that's just very related to the Bhinneka Ika Tunggal issue, but to what extent would you see the role of the regional autonomy, that change of the decentralization, of having exacerbated those last issues you talked about concerning cantonization?
One more. Yes, please.
I'd just be interested in your views, Professor, on the position of the Arab minorities in Indonesia.
Okay, thanks very much. When I was talking to Ronit over dinner last night, she was trying to make sure that I would keep to time. So I did leave out a couple of things that I might otherwise have said, which included Bhinneka Tunggal Ika. So I have always seen that as an affirmation of the combination of diversity and unity, that it's possible, that the idea of Indonesia was constructed in a way that made it possible for people to retain their own ethnic identities within that framework. But any phrase that combines a contradiction like unity and diversity is bound to be subject to many different interpretations. So I don't think that the motto itself determines anything. I think people pour meaning into the motto as they wish to. The decentralisation process, yes, I think that is certainly part of this. It's an element in this suite of tools for cantonisation in Indonesia. Now, it's pretty clear there are reasons why Indonesia may not cantonise. There are powerful bureaucratic structures, for instance, which would stand in the way. But nonetheless, in comparison with the Indonesia of 20 years ago or the Indonesia of 50 years ago, we're much closer to that prospect than we have ever been. And on the Arabs were actually the example that I had in mind when I said that my definition, or the newer definition, which emphasises disadvantage within a community, so inability to enjoy the full benefits of citizenship, it doesn't. It seems to me particularly apply to Arabs. It probably doesn't apply to Indians, although we're going to hear an expert talking about that topic. But the position of Arabs and Indians is much more to be understood in the context of the older definition of a group that is distinct from the majority, and that was actually the original intention of my title, Ambiguous Advantage, that to be a member of a coherent minority group has disadvantages, but it also has some very important advantages in terms of social trust. It gives you a community within which trust is very important, within which people have to rely on each other, because if they don't, they're absolutely sunk.
Yes, in the back.
Thanks very much for that, Robert. John Monfries, ANU. On my very first visit to Indonesia years ago, I was startled as a young traveller to read a headline indicating that the wife of the governor of Yogyakarta was engaged in judging a Banshee beauty competition. And that was, I thought, way ahead of Australian attitudes at the time. I'd be interested in your take about how historical attitudes to gays and other sexual minorities relate to what's happening in Indonesia now.
Wait, take one more. Yes, please. How? Yes.
I'm Hal Hill from ANU. Robert, thank you very much for a really illuminating talk. I don't think you mentioned refugees at all, and I'm wondering whether that might be an issue which in some ways shines a light on the subject matter, if at all. And just the context is a world with millions of refugees all over the place, and the other context is Southeast Asia, where there's been a history of informal people movement across borders. And where does Indonesia sit? I mean, if you take the spectrum as being, you mentioned John Howard before, if you take the spectrum from being on the one hand turning back boats to on the other hand, say, Turkey on the Syrian-Turkey border and what 3 million refugees sort of tolerated, Indonesia's probably closer to the Turkish end of the spectrum than the Australian turning back the boats end of the spectrum, isn't it? But is it, and does it help you kind of sort of delving into the issue? Thank you.
Ed? Okay, this.
I think you, so it's Ed Aspinall from the ANU. I think you mentioned in passing the word racism. I wonder if you could expand on the appropriateness or fit for that word to the Indonesian context, and in particular if you could reflect on its significance or applicability regarding attitudes to Papuans.
Wow. Okay. Are you sure we have still have time? So, my understanding of the history of attitudes to gays, to homosexuality in general, and to non-normative sexual practices in Indonesia is that there was formerly much greater tolerance than there is now. So we've all, those of us who are of a certain age have all seen Banci in the streets, and we all have a sense that Indonesia was once a much more, if not more tolerant, then at least a much less policed society in terms of all sorts of sexual practices. If we go back into the colonial period, there was a big scandal about homosexuality in the late colonial period, but that was very much a product of the small world of the upper Dutch colonial elite in Batavia. So not sure that that's very much I'm not sure that that's very much of an answer to your question. So I think things have become much more strict. So how on refugees and the question of the spectrum, it's very hard to suggest that the spectrum is that any single event or attitude has a particular place on the spectrum and is worse than another attitude. So when I use the term spectrum, I'm using it as someone who's colourblind and therefore doesn't see very much differentiation across the spectrum. There is a progressive end to that spectrum, which is to do with rights for Indigenous people, but it has some fairly nasty associates that arise from the same kind of understanding. Modern Turkey was created out of two major acts of genocide against the Armenians and against the Pontic Greeks. The Balkan states, I should add, were created out of acts of genocide against Muslims in the Balkan states. Christian states in the Caucasus also came out of similar genocide, so I'm not singling out Turkey in that respect. Indonesia historically had just a single case of genocide, which was committed by the Dutch in Banda, and that was a relatively small case. So I wouldn't put Indonesia in the same category as Turkey. I'm much more concerned about the general direction of events and the presence of things that can lead in the future to quite serious conflict and to the Cantonization of Indonesia. I don't think it's happened yet. It may not happen, but we seem to have much more of the pieces in place than was once the case. On refugees, And Indonesia is not facing anything like the refugee pressure that Turkey is, or that South Africa is, for that matter, or even that parts of Europe have been facing. There's advantages in not being a particularly attractive destination. But the reason why refugees are so important is that one of the forms of discrimination which we still regard as absolutely acceptable is discrimination between citizens and non-citizens. And refugees, by definition non-citizens, tend to be in a very weak position. That's why we have an international campaign to defend them. And Ed, on the question of racism. So I take the view that racism is a doctrine that assumes that genetics determines social characteristics, and that you can, moral characteristics, things like hard work, chastity, diligence, honesty, and so forth, and that you can associate those social characteristics with physical characteristics. So for me, that is racism. There has been in the past some very hardline racism, but I think that kind of biological racism is in decline everywhere. And it's in decline everywhere because there's almost nothing to support it. You go back, beginning of the 20th century, there was a strong scientific argument that the peoples of the world could be ranked hierarchically in terms of race. You looked at the world and it appeared to be ranked hierarchically in terms of race. Go forward to the 21st century, there is no scientific basis for racism any longer, and the world is no longer organised hierarchically by race. There are racial hierarchies, but the world is, you don't have to look very far for any racial ideas to be confounded. So what we have is a few troglodytes who still sit somewhere in the early 20th century, and a lot of people for whom racial categories are convenient. But the global trend in terms of ethnicity is for hybridization and assimilation. This is what happens whenever you put groups of people together. It's the story of Indonesia, and it's the story of Chinese migrants in Indonesia. There was a very large Chinese community in Indonesia before the 15th century, which appears to have disappeared completely as a result of absorption. So everyone in this room has ancestors who belonged to a very, very different culture from your culture. That's the natural state of things. It's only in specific circumstances where that assimilative process is blocked and ethnic categories become important. And official classification is also very important. Within that framework, it appears to me that there's very clearly a widespread but relatively shallow racism towards Papuans, most of which is based on educational difference. It's partly based on an easy picking up of the relics of racist thinking from the West. It can be very painful for individuals who are subject to it, but I think it's on the way out. And if we focus too much on racism of that kind, we risk not seeing the other things that are actually much more important.
Okay, I'm sorry, I think our time is up. Regarding John's question earlier, we do have a panel on sexual minorities in I just want to remind you that our next session begins immediately, so we'll have our first panel on legal and constitutional perspectives at 2 o'clock, so please don't leave. And please join me in thanking Robert one more time.
Okay, well, thanks for persisting with your attention, ladies and gentlemen. My name's Stephen Fitzpatrick. I write for the Australian newspaper for many years on Indonesian affairs and in more recent years on Indigenous affairs here, which I mention merely by way of being able to justify to my editor why I'm chairing this upcoming very interesting session on constitutional perspectives on minorities, and not, for instance, pursuing the very interesting story of the constitutional eligibility to sit in Parliament of, I don't know, a minister who appears to be making an increasing minority position for himself in his government. So our two speakers today are, of course, Tim Lindsey from the University of Melbourne, where he's Director of the Centre for Indonesian Law, Islam and Society at the Melbourne Law School, and Simon Butt, who's Professor of Indonesian Law and Associate Director at the Centre for Asian and Pacific Law at the University of Sydney. We might just get stuck straight in because I've promised them that I'm going to be brutal on keeping them to time.
Thank you.
Thank you very much, Stephen. Good afternoon, everybody. In this presentation, I want to give just a brief overview of aspects of the complex legal framework regulating the treatment of minorities in Indonesia. And this means I have to cover an enormous amount of ground and a whole lot of laws before Simon gives you far more interesting and more juicy case studies based around constitutional court decisions about how some of these laws are interpreted and applied. Now, as you can tell, he's a much better negotiator than I am. The first point to make is that, in fact, there is no coherent framework for the protection of minorities. Instead, a range of laws apply different rules to different groups, sometimes conferring rights, sometimes denying them. Coverage is patchy and some minorities are ignored. Some of these laws are very new, some far too old. Overlap and inconsistency between them is common. In fact, overall, the law regulating minorities in Indonesia reflects an all too common pattern of post-Suharto law reform. There is a clear sequence. Aspirational constitutional reform between 1999 and 2002, drawing on international conventions and norms. Heated and detailed policy debate led by civil society with sophisticated models for reform, often based on global standards. The DPR, or the government, then produced flawed or incomplete laws or regulations, typically characterised by lack of compliance measures and sanctions, and weak key institutions. Enforcement of these laws is then problematic as a result of ignorance and apathy, poor socialisation in many cases, outright resistance by government or bureaucracy to the underlying policy, very common, absent, inadequate or contested budgets, which lead to sabotaging of the program, rent-seeking, of course, and a growing culture of intolerant Muslim majoritarianism, especially influence from the Majelis Ulama Indonesia, MUI, which, although an NGO, yes, that's right, folks, MUI is an NGO, now behaves like a branch of government and is openly hostile to many religious, ethnic and social minorities. As a result, most minority rights remain largely aspirational. Now, this does not mean that laws relating to minorities are irrelevant. In fact, their shortcomings are a major challenge for minorities. I'll just make a quick mention here of the Charter of Rights inserted as a new Chapter 10A of the Constitution in 2000, modelled closely on the Universal Declaration of Human Rights, because it is the fountainhead of many of the reforms that benefit minorities that have taken place. There are provisions that protect minorities from discrimination in principle, rights to citizenship, equal treatment and so on. I won't go through them. I will, however, move to two of the more sophisticated efforts to implement these principles. And of course, another PowerPoint slide. It's going to be death by PowerPoint, so fair warning. In 2008, Indonesia introduced the anti-discrimination law, an attempt to implement the Convention on the Elimination of All Forms of Racial and Ethnic Discrimination that it ratified in 1999. The most important provision is Article 17, which imposes criminal sanctions for acts of racial and ethnic discrimination resulting in human rights or equality being limited or revoked. Discrimination here is race or ethnicity-based hate in text and speech, among other things. In other words, this law is essentially about hate speech, an area already covered by Indonesian criminal law. In fact, this aspect of this law just really replicates Article 156, not 156A, but 156 of the blasphemy law, of which a little bit more later. In fact, this law, like Article 156, is rarely used to defend minorities. Judges tend to see it more as a revival of the New Order SARA prohibitions, the prohibitions against discussing so-called sensitive topics of ethnicity, race and religion. And that was actually stated clearly by judges in their comments when they sentenced the author of Jokowi Undercover, Bambang Trimulyono, to 3 years under this law. Perhaps the most impressive of all the post-Suharto statutes intended to defend minorities is the 2016 Disabilities Law, again introduced to enable Indonesia to meet obligations under an international convention, the Convention on the Rights of Persons with Disabilities. Now, this is a sophisticated and detailed law. It's based on a far more modern social model of disability than the previous law of 97, which was long criticised by Indonesian civil society for treating people with disability as abnormal, which was actually part of the definition in the 97 Act, and as objects of charity. The new law contains a large catalogue of rights for people with disability that tracks the convention. It includes specific additional rights of women with disability. It strengthens the rights of people with disabilities to education. It gives them rights to and at work. It reiterates their political rights, their rights to religious freedom and so on. It also requires governments to guarantee and protect the rights of people with disability and, importantly, to provide social rehabilitation, welfare and protection and improve accessibility. These fine reforms are, however, yet to be fully implemented. As I'm sure will be explained in later sessions in more detail, the new law provides for the establishment of an independent National Disability Commission that will monitor and evaluate the government's implementation, and this is really the keystone of the new law. But little detail is provided, no deadline set for the Commission. It is instead left to be determined in a presidential regulation, a familiar and often fatal formula in Indonesian law. So far, the Commission has not been established, much to the frustration of disability activists, and so the law remains aspirational. Turning now to LGBTQI Indonesians, there is no legislation in Indonesia that grants protection against discrimination or grants other rights specifically to LGBTQI Indonesians, but there certainly are provisions that enable discrimination against them. For example, sodomy and lesbian sex are specifically prohibited under Aceh's Sharia criminal code, the Kanun Jinayat. Punishments famously include up to 100 lashes with a cane, and public canings of gay men in Aceh have received wide publicity. Now, except in Aceh, homosexuality is not illegal per se in Indonesia, but LGBTQI Indonesians are nonetheless subject to prosecution under general purpose laws, especially the 2008 pornography law. It's not widely understood that although that very broad term that was highly controversial, porno aksi or pornographic actions, was deleted from the law when it was passed, the concept was retained in Article 1. And the definition is extremely broad, covers voice, sound, conversations, movements of the body, performances in public. All of these are prohibited as pornography. Article 4 also contains a prohibition on even giving an impression of nakedness. Now, these provisions are routinely used to criminalise LGBTQI groups. For example, the gay men recently arrested in clubs, gyms and saunas that got headline attention around the world. The legal status of LGBTQI Indonesians has also been the cause of controversy around Article 292 of the Criminal Code. This provides that adults who engage in indecent acts with a minor of the same sex face up to 7 years imprisonment. The so-called Found Me Love Alliance asked the Constitutional Court to reinterpret this article recently to apply to indecent acts between people of the same gender, regardless of age. In other words, to outlaw homosexual sex entirely. The court rejected this, saying it was a matter for the legislature, and Simon will explain that decision in more detail in a moment. In fact, a bill to significantly revise the criminal code along the lines sought by the Family Love Alliance has been under consideration by the DPR and has been the subject of much debate. In simple terms, if passed in its latest form, it would remove the current minor requirement from the ban on same-sex acts, imposing 18 months jail for any indecent act, perbuatan cabul, with any person of the same sex as long as in public. Heavier punishments would apply where the offences are aggravated, violent or with a minor, and these would not need to be in public. Now, if passed, this provision would probably extend to same-sex displays of affection in public, and it could be widely applied to persecute Lgbtqi Indonesians, which is the concern. Let me now turn to religious minorities. Unlike Lgbtqi Indonesians, religious minorities do enjoy specific legal protection, but it is deeply flawed, and they have become increasingly vulnerable to discriminatory criminal prosecution as Muslim intolerance rises. Religious freedom is, of course, guaranteed in the Constitution. You can see the provisions behind me. But these freedoms are subject to two major limitations. The first appears in Article 28J2 of the Constitution. This allows any rights in the Constitution to be limited to secure public order, in accordance with, among other things, religious values. Now, in the blasphemy law case, the Constitutional Court found that this gave the government an almost completely unlimited power to restrict rights, including freedom of religion and other supposedly non-derogable rights. And they can do this in accordance with the advice of parent religious groups. Effectively, that decision makes religious freedom for minority religions, or at least confirms, actually, that religious freedom for minority religions is almost entirely contingent on the whim of the government, and that is increasingly determined by MUI, which, according to a presidential regulation in 2014, is formally the government's partner and guide in Islamic issues. The second major limitation of religious freedom arises from the distinction between religions and beliefs, which stems, in fact, originally from the blasphemy law, which only recognised 6 religions but says other beliefs are not prohibited. That's actually the source of that categorisation. Beliefs are, in theory, legal and legitimate, but in reality, second-class faiths. They are not under the authority of the Ministry of Religion. There are not significant budgets for them. Until recently, faiths therefore could not be included in the religion section of identity cards, which could only mention the big 6 religions or be left blank. Now, again, a recent Constitutional Court decision has changed this, but it has not really resolved the problem for followers of beliefs. And again, Simon will bring you the good news or bad news on that. Beliefs are also highly vulnerable to prosecution for blasphemy for 2 reasons. The first is a process by which similarities between ideas and practices of a belief, a non-religion belief, similarity between its ideas and practices and the ideas and practices of a recognised religion are constructed so that the belief is seen as a deviant form of the religion, and therefore inherently, by its existence, a slur on the religion and thus blasphemous. The well-known case of Leah Eden is an example of this, where a sect leader is convicted for blaspheming Islam because she believes she communicated with the angel Gabriel, Jibril, for Muslims, the messenger of God. The second way in which this happens is that statements or behaviours of a person who is not a member of a particular recognised religion, for example, because they follow a belief, can be constructed as denigrating a religion. Now, this is used for belief followers, but it can also, of course, apply to the followers of recognised religions such as Ahok, or the other case of Meliana, the Chinese Buddhist woman who complained about the noise from loudspeakers at a mosque. A further problem is the wording of the blasphemy law, particularly Article 156A, and the word dishonouring or penodaan. Incidentally, Article 156 is there as well, which is the hate speech provision. Talking about Article 156A for a moment, the problem here is that there is no definition of key terms in the blasphemy law, in particular no definition of that word dishonouring or penodaan. Police and prosecutors are therefore left to decide for themselves what religious practices are prohibited by Article 156A. And for this reason, they usually turn to MUI for guidance. And MUI has exploited this to exercise what is now becoming a quasi-judicial function. Its fatwa are now usually decisive on questions of blasphemy and are routinely applied by the courts, or followed by the courts. For example, the statement of MUI followed in the Ahok case, to the great disadvantage of religious minorities, even though fatwa in these cases have no legal authority. I now come in this high-speed race through Indonesian law relating to minorities to the legal position of ethnic minorities. When we look at Adat communities and Chinese Indonesians, both minorities identified by ethnicity. Both have in theory benefited from law reforms that purport to strengthen their rights, but actually have delivered limited change. I'll begin with Adat communities. First, the good news. The Constitution was amended in 2000 to recognise the rights of minority communities that continue to apply their traditional Adat beliefs. You can see that in the slide. The Constitutional Court has been enthusiastic in defending and articulating these rights, and as a result, their rights are now recognised also in a whole raft of legislation introduced after 1999, listed above, which mainly relate to resources and the environment, but also relate to local government. Now, although they received a great deal of applause, these new Adat community rights must be consistent with national interest and prosperity, a Suharto-era concept, and they must also masih hidup, or remain in existence. And this is the catch. It is generally the case that the legislation specifically states that to be acknowledged as still alive, the Adat community must be formally recognised by a law, for example, a perda, or regional regulation. A few communities have won this recognition, but for most it is an insuperable obstacle, bureaucratic obstruction, rent seekers, and so on. Most importantly, there are generally no sanctions of violation of Adat community rights in the new laws. And as any lawyer will tell you, a rule without a sanction is not a rule. Finally, I come to ethnic minorities, Chinese Indonesians. Again, I'll start with good news. In 1998, a presidential instruction was issued by Habibie to mark a shift of policy, which famously banned the use of terms in all government documentation, pribumi or indigenous, and non-pribumi, non-indigenous, always understood as a reference to ethnic Chinese. Ministers were instructed to treat all citizens equally regardless of ethnicity. More importantly, the 2006 citizenship law ended classification of Indonesian-born citizens into indigenous or asli and foreign descent groupings. Now, despite this, legal discrimination persists. And the best example is the oppressive SBKRI, the Proof of Indonesian Citizenship document. This is a system that derives from a citizenship law in 1958, which allowed aliens to apply for citizenship to be recognised as Indonesian citizens, but was really only applied to ethnic Chinese. They had to prove their suitability to be citizens by applying for the SBKRI. In 1978, a regulation of the Ministry of Justice declared that it applied to all ethnic Chinese. In 1972, another regulation said that SBKRI had to be renewed regularly. This system was intrusive, discriminatory, rent-seeking, complex and repressive, and intentionally so. In 1996, Suharto abolished, in big inverted commas, the SBKRI requirements. But it was abolished only for those whose husbands and parents already had citizenship, that is, they had an SBKRI. There was no relief for families who did not have one, or for women, really, who still had to prove that their husbands or parents were citizens, had an SBKRI, or go through the process of obtaining it. So in Presidential Instruction 4 in 1999, Habibie then claimed also to implement this decision and abolish the SBKRI practice, but in fact he just confirmed Suharto's regulation. Women and children, in some circumstances, will still have to prove that their husbands or parents have got citizenship, and that may involve having to produce a whole range of documents, including a family member's SBKRI. There is plenty of evidence that this system largely continues in Indonesia underground, including in access to education, due to ignorance, lack of socialisation, prejudice, or just good old simple rent seeking, because this was a great system for getting bribes. So, conclusion. It's 2-point-something minutes to go. I can do this. The laws regulating minorities in Indonesia are profoundly inadequate. They include, first, some sophisticated new laws intended to prevent discrimination against some minorities, which are flawed, lack compliance mechanisms, are not properly enforced, remain largely aspirational, such as the disability law and the adult community laws. Second, some old laws that enable discrimination against certain minorities, which are enforced regularly and even more than in the past, such as the blasphemy law, which has come into a new life. Third, some highly discriminatory legal regimes that many believe no longer apply, but which in fact continue to be applied regardless, such as the Lgbtqi system. And what are the causes of all this? Sadly, the usual suspects in Indonesian law. And how many times have I stood up at conferences or written in papers this? Here we go again, the usual suspects. Poor drafting, horse trading between parties on legislation, bureaucratic failure, bureaucratic resistance, poor socialisation, widespread ignorance of laws, whatever the reason, weak enforcement, poor judicial decisions, elite intervention to protect vested interests, and of course, good old corruption. So thank you, and of course it'd be quite techy if I put up a slide to promote Simon and my new book, so I won't do that. Bang on time.
Well, thank you very much, Tim, for cutting some of my grass, at least. Things I was going to talk about already covered, which actually does leave me, does help me with timing. Over the past decade or so, Indonesia's constitutional court has issued a variety of decisions that touch on the interests or rights of minority groups in Indonesia. And Tim's mentioned customary law, communities. The court's granted some recognition to the rights of Adat communities to use their traditional resources, particularly if they need access to them for their subsistence needs, land, forests, coastal resources and the like. And in several cases, the court has decided that their entitlements cannot simply be ignored by the government when it issues rights to companies, to others, forestry concessions, for example. Tim's also mentioned some of the cases and some of the law surrounding the rights or lack thereof of religious minorities, and he's talked a bit about the blasphemy law, so I'm not going to go into that. I am, however, going to focus on two recent cases. By recent, I mean end of last year, issued by the Constitutional Court, that deal with two additional minority groups. And one is Indonesia's Lgbtqi community. In a recent case, the Constitutional Court, as Tim said, threw out a claim by the Family Love Alliance that sought to expand the concept of indecent acts or perbuatan cabul in the criminal code. And the other group I'm going to talk about today is the interests of indigenous religions or beliefs, which is what I'm going to use to describe them in this presentation, adherence to a kepercayaan or a belief. So what I'm planning on doing is just giving you a brief outline of these two cases before circling back and honing in on a few, I think, rather problematic aspects of the decisions by Indonesia's Constitutional Court. Of course, Indonesia's LGBT community has faced increasing intolerance and resistance in recent years, and this is played out in the Constitutional Court. In April 2016, as I mentioned, the Family Love alliance, or some members of that alliance, brought a case before the Constitutional Court, and they challenged a variety of provisions in the Criminal Code, one of which was Article 292. And as Tim said, that provision prohibits perbuatan cabul, or indecent acts, but only if they're perpetrated on a minor, and of course the perpetrator and the offender are of the same, and the victim are of the same gender. The Alliance also complained about Article 284 of the Code, which deals with adultery. They wanted an expanded definition to be adopted by the court. I won't talk about that aspect of the case today. I doubt that adultery is a particular minority activity in Indonesia or elsewhere. The Family Alliance wanted, of course, the court to criminalise homosexual sexual activity between consenting adults. And happily, the court turned down that request, but it did so on a technicality, which was that the court said it couldn't interfere in what it said was the legislative process. What the Family Alliance had asked it to do was to expand a criminal definition, to extend criminalisation to a particular new class of person, and that's something that courts shouldn't do. This was a quite rare example of the Constitutional Court of Indonesia exhibiting some restraint. This might appear, I think, at first glance as being a bit of a win for Indonesian pluralism, but aspects of the decision and its aftermath are deeply troubling, and I'll come back to talk about these in a minute. Wrong button. The second case that I'll talk about is the beliefs case, and as Tim said, there's been a fairly harsh history for believers of non-recognised religions in Indonesia, discrimination, marginalisation, etc. And for many years, believers of beliefs have been pushing for greater state recognition and support, and in a decision at the end of last year, the Constitutional Court seemed to clear a path towards achieving just this. And sorry to get a bit technical about it, but the applicants in this case, I think 4 or 5 people following kepercayaan, they asked the court to look at 2 provisions of the Population Administration Law, and those provisions dealt with identity cards and family cards. Now, both of those provisions said if the citizen who wants a card doesn't have a state recognised religion, they can just leave the formula part of their card, the religion part of their card blank, and they'll still continue to get government services just like everyone else and to be entered into the population database. Now, the court decided that this was discriminatory because it treated religions and beliefs differently, even though they shared a similar constitutional status. And the court's solution was instead to permit people who follow a kepercayaan to have penghayat kepercayaan, or follower of an indigenous belief on their family card and on their identity card instead of just leaving it blank. Again, might look good on paper. It's a much better decision than the LGBT case, but there are lots of problems with this decision too, particularly in the implementation. Now, circling back to have a look in a bit more detail at the court's decision in the homosexual intercourse case, the LGBT case. While conservative Islam may have lost the battle in this case, I think conservative groups may yet win the war in the Constitutional Court for reasons I'll explain. The court has 9 judges, and only 5 of them rejected the case. And as I said, they did this basically on a technicality, a jurisdictional technicality. 4 judges dissented, and they would have expanded the definition of in Article 292 to prohibit consensual homosexual intercourse. And these judges were then Chief Justice Arif Hidayat, then Deputy Chief Justice Anwar Usman, and Justices Wahyudin Adams and Aswanto. Now, how did they reach their conclusions? Well, they were based on Pancasila and the concept of Ketuhanan Yang Maha Esa, KYME, as I've got on the slide there. They suggested that Pancasila's first principle was the most important of the Pancasila principles, didn't explain why, and also emphasised the fact that Pancasila was the source of all sources of law in Indonesia, pointed it to various religion-related rights in the Constitution, pointed to provisions which say that the state is based on Almighty God, and concluded that this meant that all laws and judicial decisions must reflect religious norms and laws. Here I come to a quote. If the status quo is maintained, the minority said, then constitutional supremacy and the authority of the law in Indonesia will be severely threatened, because a law that contains the phrase, by the grace of Almighty God, will in fact contain legal norms that at least narrow and reduce the scope of culpability of a crime that has been clearly established by the law of God. The court here seems to be talking about how all Indonesian laws on their first page are often proclaimed to come into existence with the blessing of Almighty God. And the minority concluded with the statement, or the quote below the last point here on the slide, the incidence of people taking the law into their own hands, which the community is doing against perpetrators of prohibited sexual relations, happens because the religious values and living law of the community in Indonesia does not have a place that is proportional in Indonesia's criminal law system. Now, this might fall short of endorsing vigilantism against homosexuals, but I think it comes pretty close. And at the very least, I think it portrays violence as an understandable reaction. From a legal perspective, I'm sorry to go down this path, but a serious shortcoming of both majority and minority decisions in this case was that they made assumptions about what the norms of the religions practiced in Indonesia were, but supported them with no evidence, even specific references to religious texts. Instead, the court presumed that all religions and beliefs in Indonesia prohibited both homosexual sex, adultery, and the like. Both the majority and the minority also seem to accept that homosexual sex posed a threat to the family and the nation because they destroyed the social fabric of Indonesian society. That's a quote from the judgment. Yet evidence was neither provided to support this conclusion nor to explain precisely how damage was defined, caused, or quantified. That this decision was so close, I think, does not bode well for the future of Indonesian pluralism, at least in a constitutional court sense. The outcome appears to have teetered on a nice edge for about a year, with early rumours suggesting that initial drafts of the decision found in favour of the family love alliance, with a 6-judge-to-3 majority. And in fact, as it turns out, the result might have been the opposite had former Constitutional Court Judge Patrialis Akbar not been removed from office when he was. Thank God for corruption. In early 2017, as you will know, the then serving judge was arrested for taking bribes and was removed from office soon thereafter. He was on the panel of judges hearing the case. He was there questioning witnesses, asking questions of the applicants and their lawyers. But by the time the decision, before I move on to that, he was reported to have shown sympathy for the views of the family love alliance during the proceedings. And so if he remained on the bench, speculation, but perhaps the result might have been the opposite. The minority view might have carried the day in the event his replacement, Saldi Isra, voted with the majority. But the almost equal division amongst the court suggests that the minority thinking could one day become or be adopted as a majority view, particularly if one or two judges are replaced as judges retire. And this is a real possibility because the current Chief Justice, Anwar Usman, and the current Deputy Chief Justice, Aswanto, were in the minority when the court handed down its decision at the end of last year. Also really problematic was that the majority in this case specifically said in the judgment it couldn't help the Family Love Alliance, it couldn't grant them a victory in this case, but that didn't mean that it necessarily rejected the ideas behind the application. In fact, when some elements of the media came out and suggested that the court was pro-LGBT, the court almost immediately convened a press conference to say that it wasn't, and to express that it was quite worried about the social phenomena about which the applicants had complained. Now on to the beliefs case, which is better news than the previous one, thankfully. This case was also brought in 2016, this time by several believers of a belief, like a percayaan. And as I said, they complained about aspects of the population administration law to do with what should appear on a IKTP and a kartu keluarga, a family card and an identity card. And here I've got just a mock kind of Google search example of what a KTP might look like without an agama specified in the agama column of the IKTP. There's also a kartu keluarga here, and you can see there's an agama column there too, which would normally be blank if the provisions of the population administration law were followed upon the application of a person of a belief, a kepercayaan. Now, the people who brought this case before the Constitutional Court had suffered all sorts of difficulties because they either couldn't get a card, either one of these two cards, or they had got a card but it was blank. Some even admitted to the court that they had lied so that a religion they didn't follow was on the card, and they'd done that just so they could get access to particular government services. They claimed that they had trouble getting marriage certificates, birth certificates for their children. Some had found it hard to get a job, particularly in the public service. Accessing social security was difficult for them, enrolling their children in school, even opening a bank account, and finally organising burial in a public cemetery. The court decided, as I said, that the religions and beliefs were constitutionally equal or of the same constitutional rank, and so to differentiate them along these lines, to say that, you know, if you leave the religion column blank and you'd still get public services, but not to allow formal recognition of that belief on the card, and that was discriminatory. Instead, the court's solution was to allow believers to put in the religion column kepercayaan terhadap Tuhan Yang Maha Esa, so belief in Almighty God. Interestingly, the court did not suggest that believers should be able to put their specific belief on the card. So what specific the specific name of the belief they followed on the card. It seems pretty clear that this case is an advance for religious freedom in Indonesia, but it's not really clear how far that advance goes. And I think there are a few things to note that give me, other observers, cause for a bit of concern. One is that the decision is very clear that it doesn't extend constitutional acknowledgement to all beliefs practiced in Indonesia today. The court was very careful to confine its application of its decision to the beliefs in ketuhanan, or that are associated with a belief in Almighty God. Now, this is not at all constitutionally controversial in Indonesia. I mean, Pancasila says it, there's other provisions in the constitution that say it. But it probably does leave those with a belief that's not monotheistic in the same position as they were before the court's decision. Another issue, I suppose, is that the court's solution, which was to allow people who have a belief to put penghayat kepercayaan in the religion column, doesn't entirely remove the discrimination. Full recognition, I would argue, appears to require citizens to be able to list their specific belief, and not just that they have a belief that falls outside of the recognised religions. If you looked at it from the perspective of recognised religions, the court's solution is equivalent to allowing them just to put the word religion or agama in the religion column, not the specific religion that they follow. And no doubt the established religions would reject this. The third problem, I think, with the decision is in its implementation, which, of course, you know, in Indonesia is a common legal problem. Tim mentioned it too. Soon after the court issued its decision, MUI held a national conference and in its documents criticised the decision for treating religions and beliefs as the same status, having the same status. And it called for separate identity cards to be issued for people who follow beliefs. And it seems that the government followed this idea. I'm not sure if it was a coincidence or whether it was it felt compelled to respond to the council. And what the government announced was that there would be two different types of identity cards. They'd be the same, except that religions would have the agama line and could put a religion in, and people who follow beliefs could just have kepercayaan terhadap Tuhan Yang Maha Esa next to a kepercayaan column in their identity card. So still not a specific mention of the particular belief. Now, I have not been able to find any implementing regulation. So I think, and I'd welcome any belief, any suggestions or information to the contrary. I've not been able to find any implementing regulations in respect of identity cards, and so I presume that people rocking up to a local registry office trying to obtain a belief identity card might be turned away on the grounds that they don't exist yet, almost a year after the Constitutional Court's decision was issued. But there has been some progress with family cards, kartu keluarga. And I can say that because I have a circular that's been issued by the Ministry of Home Affairs that everyone thought was needed to implement the Constitutional Court's decision. And it provides for 3 different types of family card. One for families, all of the members of which are a particular religion. One whose family members are all members of a particular belief, and one with a campuran, one with a mix of people in a family who may have a religion and others in the same family having a belief. We don't have much data on whether local registries are allowing these types of application to be made. I've got some very generous funding from the Indonesia project to work on research with UGM to look into this very issue. But we haven't got very far at this stage. Last thing I'd say, I'm running out of time, the decision does very little, of course, on a practical note, to end the everyday discrimination that not having one of the established religions on one's official documents brings. And unfortunately, this case doesn't and can't really affect that. Oh, I don't know how that slide got on the end.
Strange, isn't it?
Thank you very much.
Thanks very much, both Tim and Simon. brilliantly done, because they both threatened to stand over me earlier and that they were absolutely not going to keep to time, so they've done really well. Now we'll go as per the format. We'll take 3 questions at a time. Please introduce yourself. Please make it a question, not a comment. I'll Tony Jones the hell out of you if it's a comment. And well, let's start with Sydney. There's a mic coming down.
Thanks, Sydney Jones from IPAC. It's clear that the Constitutional Court is going downhill, right? And its justices are getting weaker, more partisan, more incompetent, and more corrupt. That's been a kind of pattern. So what is there institutionally, aside from the Constitutional Court, to protect minorities according to some of these flawed laws? If the Constitutional Court can't do it, what are the other institutions that there's any hope for? Thank you.
What, go over to here.
Just ask a simple question.
Yeah.
Thank you, sirs, for the excellent presentation. My name is Kevin from the ANU. My question is probably similar to Mrs. Jones' question, which she puts way more eloquently than me. But it appears that since the presentation comes along as the legislative and judicial framework for protection of minorities seems to be very imperfect, and it seems that protection of the minorities are only relying on courts whose judgment will not pass a first-year law course in Australia. But so do you think there's a case to be made for an equivalent of the Australian Law Reform Commission in Indonesia that could propose and change systematic changes to, and perhaps for example, changing the defamation or blasphemy laws into similar to a tort case, which involves damages instead of criminal activity? Thank you.
And we'll take one more.
The arguments in relation to the LGBT case, LGBTIQI questioning, etc., for the MK were provided, most of them by Komnas Perempuan, right? And they made several arguments. First of all, there was also the case against rape, right? So apart from adultery and homosexuality, the case was also rape, and that's where Komnas Perempuan said, because it was the extension of rape, that men could also be raped. That was accepted, and has that also been accepted by the MK? Because if Komnas Perempuan accepted that yes, we should change that. But the other arguments to adultery and the extension of homosexuality was that it's not a matter of religion, but it's a matter of protection of privacy. What happened to that argument? I lost that. Was it somewhere up in the air? Has it ever been repeated? Has it ever been argued against it?
Thank you very much for some great questions. I'll take a bit of a stab at them and then I'll leave some scraps for Tim.
Balas dendam.
Yeah, that's right. I can't remember reading anything in the judgment about privacy in terms of what the court said. So it's not uncommon, unfortunately, for quite convincing, strongly put arguments to be completely ignored by a court. In a way that, I know I shouldn't make comparisons with Australia, although Kevin does, so maybe I'm allowed. A way that it would just not be appropriate in most other courts, just to let something strongly put by a respected institution just to go by the wayside without even, giving it some air and then rejecting it and giving a reason. Unfortunately, the courts of Indonesia will often just ignore stuff that they don't want to have to address. It's a sad fact of life. There are many areas of Indonesian law where we in Australia, many other countries of the world would view them as civil matters. Many commercial disputes, most companies wouldn't dream of bringing criminal proceedings because they want some money. And perhaps blasphemy might be kind of categorised as a civil matter, but under Indonesian law at the moment, unfortunately, it's criminal. You talked about law reform and law reform commission. Indonesia already has the Badan Pembinaan Hukum Nasional, which unfortunately most people ignore. But as a new female judge of the Constitutional Court, who I think was head of that institution, so maybe she'll be able to kind of adopt some of its views a bit more consistently. I'm very disappointed with the Constitutional Court, Sydney, as you know. I think it started off very well, particularly in context. And we all saw it as I think political scientists and lawyers both saw it as a bit of a breath of fresh air. But I was always worried about this failure to develop a consistent line of judicial reasoning. And unfortunately, I think we're seeing some of the consequences of that. But as you mentioned, personalities in the court, lack of integrity, lack of expertise is a real problem. I think we may be scraping the barrel in Indonesian constitutional law expertise, and this is probably a product of the many decades under Suharto where if you learnt constitutional law, you studied it and you taught it, your course was pretty short. Because you just read out the 1945 Constitution every lecture, pretty much. There's no jurisprudence, no critical analysis of it. And I think we're seeing the unfortunate fruit of that tree. There is one hope, I think, and I had a picture of him up there on the slide, Professor Saldi Isra, who's a good constitutional law scholar. I don't know about the integrity, but I've got no reason to doubt as yet. I think he may have had something to do with some of the more progressive decisions on the court where he was writing judgments. I was hoping that he would get appointed Chief Justice recently, but it didn't happen. He was probably a bit too new. But if he gets appointed Chief Justice next time round, there's a hope that the court might be able to claw back a bit of its reputation.
Yeah, thanks for those questions. I think we have to just understand that the starting point, the basis of the judicial system in Indonesia is dysfunction. That's the underlying default position of all the judicial institutions in Indonesia. And every now and then, efforts are made to change that, to create a model court that will lead change among the others, or to reform an existing court. Constitutional Court was part of that. I mean, it was intentionally set up because nobody trusted the Supreme Court to deal with constitutional questions. Indonesia had never had a court that could review laws against the Constitution at the national level, ever. Briefly against state laws against the Constitution under the federal Constitution for a very short period. But this is the first court to review national laws against the Constitution. No one trusted the Supreme Court, so this was the way out was to create an entirely new court. And under Jimli and under Mahfud, poor old Mahfud, real efforts were made to create a court of intellectual rigour that delivered reasoned judgments and encouraged a proper jurisprudence and a lawyer's approach to law. And I think there was a great deal of success, particularly under Jimli, still under Mahfud, although perhaps less so, but it has certainly deteriorated very significantly since then. And we may be, I mean, I don't think it's quite certain yet, but there is a trend that could lead us towards defaulting back to the standard dysfunction. And if you look at the Supreme Court too, the court that no one's trusted, there have been huge efforts to pull that into shape. Huge efforts to reform it internally. But, and I think administratively, that court and all the courts are better than they were. You couldn't get a lot worse. They certainly have improved themselves. They're much more efficient and transparent, but they're still highly problematic and they are still riddled with corruption on their own admission. That's not an allegation, that's an admission from the courts themselves. So those problems are profound. And also I think the Supreme Court has in particular recently developed a deep anxiety about negative popular opinion. It was a target of criticism in the Reformasi period, and it is highly anxious about being criticised publicly because of the scrutiny that will follow, and it is becoming a populist court. It very rarely ever takes a view contrary to headlines in the lead up to a judgment, almost never. So Now, the interesting thing about this is the Constitutional Court can make the declarations it chooses. It's then up to the government to pass regulations to implement those ideas, and it's up to the Supreme Court to follow that guidance. But the Supreme Court won't necessarily do that. It often refuses to do so unless the government's passed a regulation. And so if you wish to ignore the Constitutional Court, the government can be slow in passing a regulation, and the Supreme Court can simply say, well, therefore we can't do anything. And there are quite a few decisions of the Constitutional Court that have simply gone nowhere. Of course, if it suits them, they will implement them without the regulation in the Supreme Court. So this situation is one where, even with the Constitutional Court's problems, even if it gets it right, it's difficult for that actually to become reality. So for all those reasons and the reasons Simon's explained and I've gone through, yeah, I think it's fair to say you can't rely on the courts to implement these reforms. And so here we come to the big question, which two of you asked, who can do it? Well, the answer to that, I think, is pretty clear. The ones who delivered these reforms in the first place, they weren't delivered by courts. And they were delivered reluctantly by politicians. They were delivered by civil society. This whole reform agenda was driven by civil society in that period 98 through to 2002, 2003. They're the ones who did it, and they're the ones who push the agenda, and they're the only ones who really get things to be implemented. So it's over to them. And here I will stop my rant by saying that the problem of the chilling of civil society over the last, particularly the last, well, over the Jokowi term, but in particular over the last 18 months, the introduction of the mass organisations law, the various moves against them, that is highly problematic, not because of the content of those moves, but because by chilling civil society, you pull out the driver of reform that sustains it and might allow it to be implemented. And if that goes, everything pretty much stops, which I think is quite likely to happen.
I wonder whether we've reached the golden rule in panel speaking, where it would take longer to ask and have answered a question than it would to get to our finishing time. I think that'd be the case, wouldn't it?
Oh, yes. That's why I did it.
Well, thanks very much, both Simon and Tim, for an excellent and engaging panel.